Judgment in the matter of the King on the application of Cobalt Data Centre 2 and another against the Commissioners for His Majesty's Revenue and Customs.
This case is about the operation of a time-limited tax incentive regime designed to encourage early private investment in enterprise zones in the form of building development. The aim was to start the regeneration of such zones and get them going, so that other investors would come in later for ordinary commercial reasons without the need for tax incentives. The case is also about the effect of elaborately drafted contractual agreements intended to allow investors to keep their options open while preserving their right to make use of the tax incentives under the regime. Investors seek to do this where they are not initially sure what building they want to construct, and the buildings are eventually erected after the initial period of incentivization. The tax incentives in question are 100% capital allowances in respect to the building costs, meaning that the amount of those costs can be set off against the relevant taxpayers' profits or income when calculating the tax they have to pay. These are very valuable tax breaks. The capital allowance regime is that set out in the Capital Allowances Act 2001. The key provision is Section 298, subsection 1 of the 2001 Act. This provides that to qualify for the allowances, the time limit for expenditure on the construction of a building is A, 10 years after the site was first included in the zone, or B, if the expenditure is incurred under a contract entered into within those 10 years, 20 years after the site was first included in the zone. The case is concerned with the extended time limit under subparagraph B and the meaning of expenditure being incurred under a contract entered into in the first 10-year period. The enterprise zone in question is the Tyne Riverside Enterprise Zone, which was established for the period 19th February 1996 to 18th February 2006. The owner of the relevant site within the enterprise zone did not build within that period. Realizing that the enterprise zone designation was coming to an end, in early 2006 they took steps to preserve the ability to claim capital allowances pursuant to Section 298, subsection 1b, in respect of future construction work. They incorporated two wholly owned and controlled special purpose companies to achieve this, one designated as the developer and one designated as the contractor. 2 days before the 10-year deadline, the developer and the contractor entered into a type of building contract which has come to be known as a golden contract. A golden contract is designed to keep the developer's building options open for as long as possible, whilst preserving the ability to claim the capital allowances when construction eventually takes place before the end of the long-stop 20-year period. A golden contract sets out a range of alternative construction projects, each described in detail, between which the developer is entitled to and obliged to choose. The golden contract in this case gave the developer the right of selection of one out of 6 specified projects, called Works Option 1 to Works Option 6. The golden contract contained the relevant JCT standard form of building contract, with certain specified amendments agreed by the parties. By Clause 12 of the JCT standard form, as incorporated in and amended by the golden contract, the developer was given a right to change the design, quality or quantity of the works included in the detailed specifications. At various times between February 2009 and April 2011, the developer purported to exercise both the right to select an option and the right to change the designs under Clause 12. The developer and the contractor also purported during this period to vary the golden contract so as, among other things, to enable the developer to select more than one of the specified works options. Pursuant to these arrangements, the contractor built 3 data centres on the site called DC1, DC2 and DC3. The buildings differ in significant respects from the subject matter of all of the works options set out in the golden contract in its original form. In April 2011, the appellant taxpayers purchased the benefit of the golden contract from the developer in relation to DC2 and DC3. In their tax returns, the taxpayers claimed for capital allowances pursuant to Section 298, subsection 1b, arguing the developer had incurred expenditure under the golden contract in respect of DC2 and DC3. It is sufficient to discuss DC2. The taxpayers claimed capital allowances in respect of the construction of DC2 in the sum of £153 million. HMRC denied the taxpayers' allowance claims. The taxpayers appealed. The Upper Tribunal allowed their appeal. HMRC appealed to the Court of Appeal, which allowed their appeal, and the taxpayers have now appealed to the Supreme Court. This court unanimously dismisses the appeal. 3 issues arise. First, was the relevant expenditure triggered by the exercise of the developer's unilateral rights to select and to change the works pursuant to Clause 12, as contained in the original form of the Golden Contract, so that it can be said that it was incurred under a contract made within the initial critical 10-year period? This issue depends on the interpretation of Clause 12 of this particular contract. Second, if the answer to the first question is no, does Section 298, on its true construction, enable expenditure incurred by reason of a variation during the second 10-year period of a contract originally made in the first 10-year period to be treated as expenditure incurred under the original contract? This issue depends on the proper construction of a statutory provision, Section 298. Third, if the answer to the second question is yes, was the relevant expenditure triggered by a variation of the Golden Contract, as the taxpayers argue, or by replacement contractual arrangements, as HMRC argue? This issue depends on the operation of common law principles regarding the general law of contract. On the first issue, in agreement with the Court of Appeal, the Court finds that the construction of DC2 and DC3 was not covered by the selection and change rights conferred on the developer by Clause 12 of the Golden Contract. Therefore, the taxpayers could not rely on that argument to say that the construction had taken place under a contract made within the first critical 10-year period. The second issue is therefore important. The taxpayers objected on procedural grounds to HMRC raising its separate argument based on the interpretation of Section 298, which it now puts forward, because it had not been raised in the Upper Tribunal. However, it was raised by HMRC in the Court of Appeal without objection being taken by the taxpayers. The Court of Appeal dealt with it, albeit it held against HMRC on the point, and it is procedurally open to HMRC to present its current arguments on the interpretation of Section 298 in the Supreme Court. This court overturns the reasoning of the Court of Appeal on this issue. The interpretation of statutes, and taxing statutes in particular, requires close attention to the purpose of the provision in issue and a realistic view of the transaction to which it is alleged to apply. The Court analyses the wording of Section 298, the statutory context, and a statement made by the government to explain this legislation when enterprise zones were created. The Court concludes that the purpose of the time limit in Section 298 is that the construction of buildings attracting 100% capital allowances should have occurred within the 10-year period of the site being included in the enterprise zone, or, under subparagraph B, should have been the subject of a contractual commitment entered into within that initial 10-year period. This construction gives proper effect to the intended operation of the incentivisation regime created by Section 298, whereby the actual construction of a building or a contractual commitment to construct a building entered into within that 10-year period could be expected to give other investors confidence about how well the enterprise zone was taking off and to attract other investment within the zone after that initial incentivisation period had come to an end. The relevant expenditure on DC2 and DC3 did not meet this requirement. The obligation to construct those buildings was the result of a variation of the Golden Contract made after that 10-year period and was not the result of a contractual commitment entered into within that period. Therefore, the taxpayers are not entitled to the capital allowances they claim. In the light of this analysis, the third issue, whether the later arrangements amounted to a variation or a replacement of the Golden Contract, which had been critical for the Court of Appeal, is not decisive. Even if the later arrangements were a variation of the Golden Contract, that would not satisfy the requirement in Section 298, subsection 1b. However, since the Court of Appeal addressed this issue, with different views being expressed, and this Court heard full argument on it, and since this Court does not agree with the reasoning in the Court of Appeal, this Court considers it to be of public importance to discuss the applicable principles. The basic principle is freedom of contract. Whether a change in a contractual arrangement varies the original agreement, keeping it in place with some amendments, or discharges and replaces it, depends on the intention of the parties. However, there are some outer limits to that principle. It is possible for there to be exceptional cases where a court will not give effect to the party's intention, if to do so would bring the law into disrepute and damage its legitimacy in the eyes of the public. This court does not find it necessary to reach a conclusive view regarding the application of these principles to the particular facts of this case. As I have already explained, the appeal must be dismissed because the taxpayers fail on the issue of the proper interpretation of Clause 12 and on the issue of the proper interpretation of Section 298.